In a community property state such as California, everything, all the properties acquired during the marriage are considered community properties. 50-50 division. Is that the end of the analysis? No. Let's take an example. Let's assume you and your spouse, you got married and you purchased a property, let's call it a house, and you fronted the down payment out of money you had in your possession before the marriage, or let's say your parents gave you the money. Would that down payment be considered part of the community property? No. That down payment that came from money you had before the marriage or your parents gave you is separate property and will be reimbursed to you as your own separate property. Let's take a different example. What if a couple get married, but one of the spouses had a house before the marriage under his or her name, and they live together for 20 years? Is that house still the separate property of the spouse that had the title of the house before the marriage? Basically, the title would be yes for that spouse, but the community acquired interest in that house. By paying the mortgage, by maintaining the house, the community acquired interest in the separate property of the spouse. How much is this interest? That is to be determined by a lawyer and by the accountant. This is the answer for the question, what does it mean that California is a community property state? For more information, please visit us at SariehLaw.com.